But when he got tired,
Good morning, everybody. Oh. Hello. Hi. Welcome to the National Press Club. I'm Allison Fitzgerald Kojak. I'm the president of the Press Club. I'll be hosting this Newsmaker event this morning, and we'll get started in maybe 5 minutes or so. So I'm going to ask you all now to take a moment and look at your cell phones and make sure that the ringers are off, they're turned to vibrate, whatever it is you need to do to make sure that they don't ring in the middle of our press conference. After our guests make their remarks, I'm going to start off with a few questions, then open the floor to questions from journalists. When it's your turn, please identify who you are and what your news outlet is. We'll allow as many questions as our time permits. We'll also be taking some questions via email from our people who are following along on the web. So if you do have questions, and you can hear me now, which I don't think you probably can, questions@press.org is the way to send them in. We'll get started in just a few minutes. Thanks. Judy, you're here. Thank you. And Jeremy, you're here. In case your names are on that. Good morning.
Let's share this one. Sure.
Good morning, everybody. Welcome to the National Press Club. My name is Allison Fitzgerald Kojak. I am the 112th president of the National Press Club, and I am the Washington Investigations editor for the Associated Press. We're very happy to see you all here at the club today, and we also welcome all of those who are participating via the web. When we get to the Q&A portion of the program this morning, those watching the news conference online may submit questions by sending them to questions@press.org. Today we're going to be talking about a topic that's divided public opinion around just what our country stands for, immigration. And our panelists, who've traveled a long way to be here today, know the issue firsthand. To my immediate right, I have Judge Ashley Tabaddor. She's a federal immigration judge charged with the juvenile docket in Los Angeles. She'll be speaking in her capacity as president of the National Association of Immigration Judges, the union that represents the nation's more than 400 immigration judges. Beyond Judy, she's joined by Ashley, she's joined by Judge Judy Perry Martinez. I said judge. No. She is not a judge. Please forgive me. The national president of the American Bar Association. With more than 400,000 members, the ABA is just a little bit bigger than the National Association of Immigration Judges. Ms. Martinez is a lawyer based in New Orleans. She recently returned from a week of pro bono work along the border with Mexico, and I'm sure she'll have a lot to say about what she saw there. And rounding out our panel is Jeremy McKinney, who serves as the second vice president of the American Immigration Lawyers Association. AILA represents the nation's 15,000 immigration lawyers. I walk by the AILA building all the time because they're about a block away, but Mr. McKinney practices in North Carolina. A little context for our conversation this morning. Last week, the TRACK project at Syracuse University, which reports on immigration and enforcement data, reported that the backlog of immigration cases for the first time has exceeded 1 million cases. In recent weeks, the Trump administration has set up temporary courts on the U.S. southern border and imposed more restrictive policies for asylum seekers. And in an effort to speed along cases, for the first time, immigration judges are required to hear a minimum of 700 cases per year or face disciplinary action, including possible removal. So we have a lot to talk about this morning, so I'm going to turn it over to Judge Tabaddor to start us off.
Good morning, everyone. Thank you for...
Can you speak into the mic?
Oh, sure. Thank you. Good morning, everyone. Thank you to the National Press Club for sponsoring us. Thank you, Allison, for serving as a moderator today. It was great to meet you. We're a long-time fan, so I'm happy to be sharing the stage with you.
Well, thanks for being here.
Thank you to our co-panelists, Judy and Jeremy, for joining us today to talk about this really important subject that has been plaguing our country recently. As we just talked about, the Immigration Court just broke the 1 million threshold backlog of cases pending before the court. And this is in spite of the largest ever hiring trend that we have seen. In the last 3 years, we have hired, or the agency has hired, well over 170 immigration judges. We went from under 300, maybe about 280, to about 420 immigration judges. And yet we went from about 600,000 cases to 1 million cases in just this short period of time. And over the last few years, the last 3 years, and in particularly the last few weeks, the Department of Justice has taken very dramatic and revolutionary steps to dismantle the court and strike, honestly, at the very core of the principles that we as judges and Americans hold dear. I want to do a really quick summary of highlights. In May of 2018, former Attorney General Sessions reversed 4 decades of precedent in a single stroke. In a precedent decision, he removed the key docket management tool that judges have been using to manage their docket. This tool is known as administrative closure. And with that one single decision and single stroke, he added a prospect of 300,000 cases to our backlog. Moving on to October 2018, Allison alluded to it, the department struck another blow to the heart of independence through the imposition of quotas and deadlines as a condition of each judge's continued employment. I can understand that sometimes when you think about 1 million cases, 600,000 cases, quotas may seem like a reasonable response. Not when you're dealing with judges. This act intentionally created a conflict of interest in each case where the judge's livelihood is now being pitted against his or her duty to be an impartial adjudicator. Through quotas and deadlines, the agency is imposing its law enforcement policies and position into each judge's ruling by essentially threatening the judge's job. Every judge now has a sword hanging over his or her head on a daily basis. A third major strike has been the deliberate withholding of key resources for effective functioning of the court. There's a litany of ways in which resources have been withheld from lack of support staff, law clerks, space, technology. But one example I want to highlight is interpreters. Over 90% of individuals who appear before the court require interpreters for these proceedings to be considered fundamentally fair. Yet, in spite of historic increases in the department's appropriation by Congress, the agency has cut the funding for allocation of interpreters for cases. It now refuses to provide more than one interpreter per session. And let me put it to you in context. Our sessions include sometimes 80 to 100 cases with multiple languages, 3 to 4 trials with multiple languages. This is what we've been forced to handle, and yet we are limited to one interpreter per session. And now, in certain instances, not even that for certain initial hearings. And finally, in the last months, the department has struck a fatal blow to the heart of judicial independence and integrity. It published a regulation that reversed decades-old key safeguards imposed on the director of the Executive Office for Immigration Review, EOR, which is the agency within the Department of Justice that oversees the court. Without prior notice to the judges or the public, made effective immediately, the department collapsed into a single individual the role of the chief policy director with the role of the chief appellate judge. Let me repeat, the chief policy director with the chief appellate judge. This means that the EOR director, who previously was prohibited from engaging in any judicial role over cases because of the political nature of the position, has now been given authority to interfere in individual cases, direct the result of cases, and to sit as an appellate judge reviewing immigration judge decisions. So this radical move essentially decimates any semblance of separation of the judicial role of immigration judges from the law enforcement policy agenda of the Department of Justice. With every decision, the judge has to weigh the risk of being fired against the oath of office he or she has taken. And we have already seen the impact of this travesty with the Stay in Mexico or the MPP program, where judges have confided that they have made rulings out of fear of losing their job. And frankly, judges have good reason to fear. On August 9, 2019, the department filed a petition with the Federal Labor Relations Authority, or FLRA, seeking to decertify our organization. The department claims that immigration judges are management officials who make policy, an assertion that FLRA has already considered and soundly rejected 2 decades ago. So why would the department make the same claim now? Have our duties changed? No. We don't even have the authority to order pencils, much less manage or supervise anyone. The intention is clear: to silence the voice of judges that seek to protect the integrity of the court and disembowel the union so that the judges can be fired at will for not pleasing the department. And to make matters worse, within days of filing this petition, the department went on the attack and distributed to all EOR employees a prominently displayed summary and a link to a white nationalist blog, singling out myself and my colleague Judge Cohn, who's here today, our Executive Vice President of NAIJ, for our actions as both immigration judges and as union leaders. The blog labeled us as cretards, a word tied to anti-Semitic rhetoric, and went on the attack on behalf of the agency in support of the decertification campaign. Not surprisingly, my colleague and I have received numerous vicious, threatening messages and voicemails as a result of this agency action. The National Association of Immigration Judges stands firm in our commitment to our oath of office, the rule of law, and the American public. For that reason, just this morning, the NAIJ took legal action against the department and filed 2 unfair labor practices petition, or ULPs, with the FLRA. The first ULP seeks redress in response to the department's online attacks against NAIJ executive board members. The second seeks redress for the department's actions in withholding key information and circumventing the law on matters relating to discipline and removal of immigration judges. We are deeply engaged in the long fight against decertification of our union. We will not stand idle while efforts to undermine the independence of our courts relentlessly persist. We hope you will continue to help us educate the public about these important issues. The answer is clear. We all need Congress to take the critical step of saving the court by removing it from the Department of Justice and giving it the independence it needs to do the work Congress has asked it to do. We are past Band-Aid solutions and short-term measures. The incessant backlogs and loss of public faith in the court are insurmountable obstacles without the correction of the fundamental design flaw of having a court in a law enforcement agency. Thank you for giving me this few minutes to address you all today.
Thank you. I'm going to let our next 2 panelists speak briefly, and then we will go to questions from the journalists. So, Judy Perry Martinez, what's the position now of the Bar Association related to these actions by the immigration judges and just the situation in the immigration courts right now?
Well, thank you, Ashley, and thanks to the National Press Club as well as to our collaborators and people who work on these issues of such great importance, the American Immigration Lawyers Association and the National Association of Immigration Judges, who together with the American Bar Association continue the pursuit of justice in the immigration arena. As everyone knows in this room, this is not a new fight. It has been going on for many, many decades that we have had a situation where the system of immigration is in crisis. The numbers of individuals coming into this country in recent years, and in particularly this past year and a half, has exacerbated the emergency nature of the crisis that's before us. And it is an all-hands-on-deck moment for this country and for our policymakers in Congress as they need to move forward without delay in addressing what needs to be done. And the first action that must be taken, we believe, at the American Bar Association, as well as our colleagues that are present today and their representative organizations, believe that it is an imperative that the immigration courts become Article I courts in this country. There are models that have been very successful in this country of other immigration courts. There are many examples of their successes in rendering justice, and in the current form that the immigration judges sit in terms of being necessarily reporting to the Department of Justice as a part of the Department of Justice, it is beyond question that the job cannot be done, and we are putting these dedicated individuals in a position of trying to make the most out of what they can do with a lack of resources, a lack of independence, and much more, when in fact we should be supporting them as a nation and as a country in a way that makes their job of rendering justice one that can be done each and every day in each and every case. As president of the American Bar Association, I recently traveled down to the border, south border of this country in Brownsville, Texas. I am not an immigration lawyer. I am a commercial litigator. I was an in-house counsel for 12 years. And I will tell you that I did the same thing last year and spent a week doing pro bono asylum work at the border because of the criticality of this issue for our nation. And what I can tell you is that I saw something that does not in any way approach justice. What we know is that when we have the numbers of individuals who are striving to claim asylum in this country who are not getting access to counsel, and in fact are not getting meaningful access to counsel at the new tent court that's been stood up and now operational in Brownsville, Texas, that we have to address it. And lawyers in this country want to help as best they can, but even those who want to help are facing barriers and hurdles that are not necessary in any sense in order for the work of this court to be done. What I can tell you is that we have people who are now waiting in the Remain in Mexico program, of course, who are now waiting in Matamoros, Mexico, a place that right now enjoys a level 4 security from the Department of State level security. That is the same that is enjoyed by parts of Syria and Afghanistan, and it is a do not travel area. And yet we are asking now lawyers of this country who want to do pro bono work and those who work for legal aid organizations to go there to try to assist individuals. That is not a tolerable situation. What we also know, and I toured the tent court when I was there in late August, it was not operational yet, but what we saw is tremendous hurdles. And what we know now from on-the-ground reports of individual lawyers who have tried to go there are hurdles and obstacles to a transparent court, to a court that will be operational in a sense of the numbers that they are talking about and projecting in terms of cases coming before it. When I was there, I was told that individuals would be processed through. They have to be there at 4 a.m. in the morning at the bridge in Brownsville in order to make their court hearing some 4 and 6 hours later. And when they come to the court, they'll be processed through. Measures will be taken for security, of course. But when I asked the question about whether an individual could go into a courtroom that's set up, and there are 60 such courtrooms as I recall, and bring with them any tools that they needed in terms of pen or paper, I was told no. Can you imagine any of us going into a courtroom and having our liberty on the line and not having the ability to hold a pen and paper? The only thing they can go in with is the notice to appear that they have received, hopefully at the right address, because we also know that some of those notices to appear are being served and given to people at addresses for which they've had no relationship whatsoever, at shelters and otherwise, and they're happened to get a copy of the notice to appear because of the good works of some people who were helping. We're also told that none of the judges, of course, will be physically at the court, at the tent court. They're VTC, they're videotaped in. There are real concerns about whether interpretation will be rendered. We know at least in one case that went forth that the interpretation was of the judge's questions, but not simultaneous, full and complete interpretation of the proceedings. Again, I ask any of you, when your liberty is on the line, when you're being processed in such an important moment in your life, when you've come from a situation of trauma in many cases that none of us in this room can believe, and not having the ability to hear and have a simultaneous translation, is that something that really looks like justice that we know in this country? We support, as I said earlier, at the American Bar Association, an independent immigration court system, one that is not within the Department of Justice. These courts are making life-altering decisions on a daily basis, on an hourly basis. We have to have their independence, not only in fact, but as perceived by the members of our country, the public members of our country, because we know that the perception of independence and of full and fair, impartial court is what's critical to our nation's democracy and its values. There's so much more to tell you about, but I know we want to hear from Jeremy. Let me suggest to you that the criticality of what's going on right now is based in knowing that these individuals who are coming to our country and seeking asylum and seeking justice have access to counsel, they have meaningful access to counsel, and that they are allowed to process their claims under the laws and treaties to which this country is bound. Thank you very much.
So I'll turn it over to Jeremy. You represent the immigration attorneys. You've seen what's going on down there firsthand.
Yes. Thank you, Allison. Thank you to everyone this morning. Again, my name is Jeremy McKinney. I'm the second vice president of the American Immigration Lawyers Association, and I'm a practicing immigration attorney in North Carolina. Primarily, I appear before judges in Charlotte, North Carolina, as well as immigration judges in Atlanta, Georgia, and Lumpkin, Georgia, which we'll talk a little bit more about in just a moment. In all of that time, in over 20 years, I've never seen such an all-out assault on due process, which of course has a simple definition. It's just the right to a full and fair hearing before an impartial judge. And yet the current system that we work in every day all too often is not full, not fair, not impartial, and is wholly inadequate. So I want to start where Judy left off, and that is with the tent courts. And I can't believe I'm even using that term, tent court. In mid-September, DHS opened massive tent facilities that are now functioning as virtual immigration courtrooms for MPP cases. That's the Remain in Mexico cases. The rollout of the tent courts was shrouded in secrecy. Homeland Security did not even provide the most basic operational logistics related to the new tent courts, including the dates when the facilities were opening. Last week, AILA sent representatives to Texas, including Laura Lynch, who's here with us today, to obtain information for immigration attorneys, for our members about how to best represent clients in those tent courts. However, unlike other immigration courts, AILA representatives were not permitted to access the Laredo and Brownsville tent courts to observe hearings. DHS not only has complete control over access to the facilities, but DHS also has complete control over attorney-client representation itself at those facilities when migrants are on the United States side of the border. The MPP program erects insurmountable hurdles to attorney representation. Legal service providers able to represent individuals subject to MPP are scarce. As of the end of June, only 1.2% of asylum seekers obtain counsel. And as we all know, having representation dramatically increases the likelihood of success. It's clear that these tent courts are designed to create a deportation machine, a mechanism simply to speed up the deportation of individuals with little regard for due process. Yesterday, AILA sent a letter to DHS and DOJ requesting answers to operational procedures and basic information related to the new tent court facilities. Now, these observations, operational secrecy, access to counsel, are consistent with what we also see in the remote for-profit prisons scattered throughout the United States, including the prison I travel to the most, Stewart Detention Center in Lumpkin, Georgia. Now, Lumpkin houses about 2,000 men from all over the place, including many from the Carolinas, areas where ICE has no long-term detention space. Lumpkin is about 150 miles south of Atlanta, Georgia, in the middle of nowhere. Attorneys have fought for years just to have internet access in the courtroom, but most have found that now that you can bring a cell phone into the courtroom, you can't even get a signal anyway. There are 3 meeting rooms. Attorneys often have to wait 3 to 4 hours just to visit a client. Case preparation, evidence gathering, all are acutely more difficult to accomplish when your client is locked up there. The net result is clear. The numbers bear it out. The vast majority of detainees are unrepresented, and this year, for example, according to TRAC, the detainee has been granted relief only 2.4% of the time. That is January through August. And if you look at previous years, you will see a similar range of about 1 to 7% of the time the detainee actually being granted relief from deportation. I'd like to say that this lack of due process is just limited to this detained setting or at the border, but the hammer this administration has taken to due process impacts every immigration court. Using his power to certify removal cases to himself, as Judge Tabaddor mentioned, this Attorney General has ended administrative closure, ended the ability of immigration judges to unilaterally terminate cases, and even attacked the ability of immigration judges to continue cases. EOR itself has followed suit with performance goals and then actual quotas on immigration judges. The agency has moved to replace interpreters at the initial hearings with prefabricated videos and conduct more and more substantive hearing through video conferencing. Again, think about this tent court and other courts going on all throughout the United States. You have a judge making life and death decisions based in part on the demeanor of a witness the judge is watching on a computer monitor. In the short term, AILA lawyers, often working with our partners at the ABA and other organizations, will continue to challenge this administration's attacks on due process, and we will litigate in real court. We are already seeing the results. For example, the Fourth Circuit recently reversed the Attorney General's decision on administrative closure. Because I practice within the Fourth Circuit, almost immediately I saw local immigration judges regaining control of their dockets by administratively closing cases better resolved by another agency, such as USCIS or the Department of State. But litigation alone will not fix this problem. As AILA Executive Director Ben Johnson has pointed out before, our immigration court has a conflict of interest built into it. The Department of Justice is a law enforcement agency, and the immigration court system is housed within it. The immigration judges and even Board of Immigration Appeals members are not considered real judges by the DOJ, simply employees of its law enforcement agency. Even worse, DOJ not only oversees the judges, but also the attorneys who prosecute immigration cases at the federal level. The prosecutors and the fact finders are in the same house. There is only one comprehensive solution here: independence from the Department of Justice. We need an independent Article I immigration court, like bankruptcy court, like tax court. The process itself should align with the stakes. Thanks.
Thank you. So I'm going to kick it off with the first question, and then I will go to the reporters in the room. Again, wait for the microphone, say your name and your news outlet. Judge Tabaddor, Jeremy just said that the current situation in the immigration court has created a deportation machine. Do you agree with that assessment of where things stand?
I think it has created a very deep conflict where the judges are very much torn between their oath of office versus what is expected of them from the department. I think it's important to look at the pressures that are placed on the judges. We are being assigned 2 or 3 times the number of cases per session that we had before. I hear from my colleagues who are being assigned upwards of 100, 120 cases for a 3-hour session, 4-hour session. That's frankly, I don't even know how you're able to get through that. It's 1 or 2 minutes. We are being told anytime that you continue a case beyond a certain period of time, judges are being asked why you continuing it past that. And we're also, as I said, in confidence, unfortunately, I'm hearing from some of my judges where they feel that they have to make rulings to protect their job rather than what they would have done otherwise. So I think the judges are doing the best they can within the limitations that have been placed on them.
Hi, Bob Wiener, Wiener Public News Op-Eds, and Allison, thanks for moderating. Okay. So Judge Tabaddor, you were here maybe a year ago, and you made a very strong, similar case for independence of the immigration courts, and also for not making the unions weaker. Many of the same cases that you're making now, which are persuasive. But I want to try to boil it down to what is the reality of change and what process is taking place to actually make it happen. So is this just a current administration situation? Although I know ABA President Martinez, you said this has been going on for decades. But now, is it just a current administration problem, or is it a bipartisan problem where you can't get the support from either side? Or have you talked with the presidential candidates, or what is the reality of legislation that you are trying to do and the prospect of passage for making something happen toward what you want?
Thank you. Really good question. So the design flaw, the sort of having a court and law enforcement agency, obviously has plagued the court from its inception. But what's interesting to sort of pause and think about is that the birth of the immigration court was from the recognition that it's untenable to have a law enforcement agency oversee the adjudicatory role of cases. So we were born out of the former Immigration and Naturalization Services within the Department of Justice. From that, there was also, again, the continued recognition that for these cases, you need to have fundamental fairness, which requires independence of the adjudicatory functions of the individuals overseeing those cases. So through time, safeguard measures have been placed, and one of them was this idea that you shouldn't have the director of the agency, who's obviously responsive to the political law enforcement measures of the department, have those judicial roles over the judges. So we have dealt with this conflict of interest over time, and step-by-step recognition within the department that these conflicts of interest are problematic. You need to be responsive with safeguards. Certain safeguards were placed, others remained in effect. Other conflicts remained in effect. So the safeguards included, as I said, divorcing the director from the adjudicatory role, making sure the judges are protected, making sure the judges are not accountable for quotas and deadlines. So certain key safeguards were made, but other conflicts remained. So we had issues where contempt authority of judges was not implemented by the department, saying, your attorneys, just like the DHS attorneys, we're not going to give you authority over them. Or in certain other measures, the department was using the court as a law enforcement tool, messaging tool. We've talked about it in terms of docket shuffling. So they would come and they say, today we want you to prioritize these set of cases over the other set of cases. And that obviously impacts the ability to provide due process, because people who've been waiting in line are now being shuffled around for reasons unrelated to due process. So we've had these issues, but a lot of progress was being made and recognition of the need to protect those fundamental core principles of an American court. However, the last few years has taken all of these conflicts of interest, these intersection points, and have crossed every line. So we saw the quotas and deadlines. We saw the collapsing of the director's role from a sort of policy person with policy and adjudication. We've seen this constant shuffling of the docket back and forth, continuing on. We're seeing interference with every element of the judge's role, and we've seen the court being essentially turned into a widget factory, where everyone and every part is being treated as if there's some sort of, property being sort of wiggled around from one to another. So the issues that have plagued the court have existed. It had been much more tolerable, I suppose. Mm-hmm. I mean, and it took the last 3 years, frankly, for many of these organizations to finally see what we've been saying from day one, which is this conflict of interest is indefensible. You will not be able to have what we as Americans, under American judicial principles, consider to be a true, fair court. In terms of legislative action, we now have had the greatest amount of grassroots efforts in securing support for an Article I court. And many people on the Hill recognize it as a matter of principle. We think it is an absolute bipartisan issue, because 3 years ago, we had people on this side yelling about all the inadequacies and unfairness on the other side. So when I talk to people on the Hill, I say, this pendulum swing has happened in within a short period of time, 180 degrees. So the one thing I can guarantee you is that the pendulum would swing back. So why not fix it now so that we can be consistent with our American ideals, so that you can ensure a win-win situation for everyone? The likelihood of success, we'll see. Right here?
Just a quick follow-up. Is there a bill that you have pushed, and is there support, and what are the prospects for the bill?
We have the Federal Bar Association. As I said, we've had the greatest amount of grassroots efforts by prominent national legal organizations like the American Bar Association, ALA, and the Federal Bar Association that have stood up in support of Article I. Federal Bar Association has drafted proposed legislation, so that's probably the closest tangible written one that has been circulated. But I don't think anyone at this table is necessarily committed to any one model. I think everyone recognizes that the correct approach is to look at the concepts. So we are open to to discussions about the actual final sort of structure of the court. We just know it needs to be out of the Justice Department, and it needs to protect those fundamental concepts.
Thank you so much for your time today. My name is Michaela Ross. I'm with Bloomberg Government. I had a question on if you see, you talked a little bit about litigation potentially, or what might be the redress be for these tent courts that we're seeing along the border. And then the second question was what you had filed this morning. If you could talk a little bit more about the ULPs and what you're hoping to see from the outcome of that, what the timeline we should be looking forward to.
Regarding litigation at MPP, we're right at the beginning. Yesterday, the American Immigration Council launched an effort to address the individuals who arrived at the port of entry before this new protocol went into effect, but were turned away. So arguably, the new protocol should not apply to them because they arrived prior to its implementation, prior to the Supreme Court, in essence, giving this administration a green light to pursue MPP. So that's the very beginning. We anticipate there'll be a variety of different litigation efforts over the next few weeks.
Do we have a question from the web? No, Dave? No, not right now. Okay.
The ULP.
Oh, okay. Excuse me.
Oh, the ULP.
For those listening via the web, you can send in questions at questions@press.org. Sorry.
Oh, sure. So an unfair labor practice, we've had to learn a lot about labor law in the last few years in this position, because that's the only way, frankly, that we have any ability to speak out loud, to shine the light of transparency and accountability on what we are addressing, and as well as what the country is saying. In terms of ULP, it's an unfair labor practice, which means that the government or any party who fails to follow the rules when it comes to labor management relations would have to account for unfair labor practice. So that petition is filed with the Federal Labor Relations Authority. It is assigned to a regional director or a regional office, and an investigation is to pursue. Based on that investigation, a complaint may be filed by the general counsel. And from that, you can take there may be settlement options, there may be steps that are ordered in response to the investigation. The time frame, frankly, I have to say, I don't know. I've been told it could be a few weeks, few months, but it really depends on sort of availability or the commitment of the Federal Labor Relations Authority, which to this date has not had a general counsel by design. So that may play a role in the likelihood of the process being expeditious or not. Sure. Oh, here.
I just wanted to follow up. Earlier, you mentioned the white supremacist article that was distributed through the
Daily News
the
briefing.
Daily News briefing.
Email.
Did you ever get an explanation for why that was distributed and/or any apology for it?
No. So what happens is we used to get a daily news briefing, which was a compilation of the daily articles from various news sources relating to immigration. It's designed by different categories, and there were certain summaries for some of the news sources. This is something that everybody would read on a daily basis. It was every morning you come in, turn on your computer, that's the first thing that would pop up. And based on that, it was actually my colleagues who came to me and said, "Did you see this? It is prominently, featured in one of the days, and it's just absolutely outrageous." So frankly, I'm usually so busy I never get a chance to sort of put in the time. But when I looked at it and my colleague looked at it, we said, "Wow, this is pretty outrageous." We wrote a letter bringing it to the agency's attention, saying this is something that seems very much out of line. And to this date, frankly, we haven't received even an acknowledgement from the agency or the director of this correspondence, and we haven't received an explanation. We heard through the press that the department had claimed that this was some sort of an oversight, but we also heard and found out through the press that actually the vendor services that are used by the department provide a very curated service to the department, after which the department reviews everything line by line down to a misspelling. And I have to say, when I first heard that, that was quite consistent with the experiences that we've had with our immigration judges being micromanaged on a daily basis, day by day, hour by hour. So it was very plausible. And when I contacted the vendor just to verify myself, to say, well, this is what I've read in the press, he told me, yes, we provide the services, we compile it, and the agency itself then makes the final call on exactly what gets prominently featured, what gets cut out, what gets included. And that's where we're at. After that, we started receiving a lot of sort of interesting phone calls and messages, and my colleague has received viable threats that has now triggered need for security. And still no apology or acknowledgement. So.
I'm just going to ask one more. So the administration has argued, and many people have argued, that most of the migrants coming from Central America are in fact economic migrants and not actual people who would qualify for asylum. Is there any, what do you think about that argument? Should the process be harder in order to discourage people who are economic refugees from coming to the United States, or no? And I'll take any of your responses.
The process is hard. It is a very high standard to meet in order to obtain relief. And as a consequence, individuals who have asserted their right to asylum or other relief, in fact, are put to the test of making sure, the law makes sure, that in fact they are and have been subject to harm or the threat of harm if they go back to their country. I will tell you that we all know that, based on data from cases in the past, that you have a 10 to 14% greater chance of receiving relief in the immigration system, of obtaining asylum relief or other relief, if in fact you have counsel. That should be the only information, the only data point that is necessary in order to make the case of those of us sitting up here in terms of how necessary it is that justice be done and that attorneys be a part of that. Access to counsel, meaningful access must be a part of it. I referred to my trip down to the border this past August, and I worked with individuals in detention. And I received word this morning when I woke up that an individual who I had met with had in fact obtained relief, and there was an order signed for his bail and for release. That was an individual who had been separated from his child in April, a 2-year-old. They had not been with each other. The child had been in one state and had been removed in care and custody of the government to another state. That is harm that cannot be taken away. That is harm that our country, those of us who all care about the values that we hold dear, cannot undo. No matter how many times we say we're sorry, no matter how many times we seek something more. If anyone believes that separation of families and children is not occurring, and we have the data that in fact it is remaining to occur in cases like the one I just described to you in this country, you should have no doubt that it's ongoing. That is but one example of harm but it's also an example of harm that has been halted because in that particular case, that individual had the services, and there are many attorneys who are contributing, but had the services of the American Bar Association's Pro Bar operation, which, by the way, is not something new. It's about to celebrate its 30th year on the border of rendering know your rights and direct legal services to unaccompanied children and to adults who are in detention and families. That one example tells you why this is so critical that we have meaningful access to counsel in these cases. And not all of them are successful. And every attorney who takes on this kind of case knows that he or she may not win, may not get the relief that their client wants. But our justice system says that those who cannot afford counsel, we believe, the American Bar Association believes, that those who do not afford counsel should get counsel, and children should in each and every case.
I can just say one quick point on this. Congress has spoken on this issue. We are represented through Congress, and as judges, we take an oath of office to stay true to the laws of this country. Congress implemented our international commitment under UNHCR, refugee treaties, that people who seek protection are entitled to certain process. Process matters. And fundamental fairness isn't a checkbox. And that's what we're seeing now. We're seeing a lot of checkboxes rather than fundamental fairness being provided to the parties that appear before the court, or frankly to the judges who are supposed to render that to the parties that appear before the court. So I think one of the things that we do is we don't prejudge cases. We don't start off by saying, oh, you're from this, you're from that, you must be X or you must be Y. And that's been one of the big issues we've had to keep reminding everyone is judges don't prejudge. You allow the person to go through the process and you ensure that it's meaningful. It isn't a checkbox. It isn't that we gave you 25 minutes on your first day in a new country, in a new courtroom, a 25-minute video about all your rights and responsibilities and highlighted how nice it would be if you just take voluntary departure and go. We don't say you have access to counsel, but we don't give you the opportunity to actually meet with counsel. We don't say you have an opportunity to present your case, but then tell the judge you have 100 cases and 4 trials to get through. So I think it's really important for everyone to really look where we are in terms of our commitment to the values that we as Americans have been committed to. I mean, the founding fathers built this country on these principles. And we're at a very critical juncture in history where we decide, do we abandon them or do we double down, regardless of whatever challenges we believe we're facing?
If you look over the past few decades, what you used to see primarily from the undocumented population, you saw predominantly Mexican, and it was predominantly male. And that was primarily due to circular migration. Individuals that needed to support their families would come into the United States and work and send money back home, or literally go back home during the winter. And that's what you saw for years. That was the look of our clients. Increasingly, every year, that population becomes more Central American and more female and more children, right? And those individuals are not economic refugees. They are fleeing unimaginable violence. I have had a client whose neck was literally slashed. He managed to live. He managed to make it here. And thank goodness, through representation and a fair hearing, he was able to win. I have a client right now at the circuit court level who was stabbed in the gut by her domestic partner. And was hospitalized for over a month before fleeing to the United States. And yet we have a former attorney general that says someone like that can't make out an asylum claim through cases like matter of AB. So yes, I agree with Judy. Asylum is very difficult. There is a narrow range of cases where your client will win. You lose a lot, right? But what we're asking for, the theme here, is due process, a full, a fair hearing before someone that has not prejudged the case, and within a system where the Attorney General has not put his thumb on the scale of justice to say, you know what, if it's domestic violence, that is probably not going to be asylum. If it's a gang-based case, it's probably not going to be asylum. Attorney General Sessions literally said that in a precedent decision. That will not do. That's yet another reason why this court system and this group, this judge corps, needs independence from the Department of Justice.
Hi, Mark Patterson from Catholic News Service. Judge Tabaddor, could you walk us through the kind of session that a judge encounters dealing with immigration cases, at least the session as it's developed under the current administration, and could you differentiate that by what was happening prior to 2017?
Sure. So the current model is designed on a assignment of large number of cases to judges. So we have a non-detained docket and we have a detained docket. So let me start by that. What that means is the non-detained are individuals who are within the country or released into the country, and the judges oftentimes have upwards of 3,000, 4,000, or 5,000 cases on their docket for that type of case. For the detained docket, it's individuals who are being held in detention. So those judges are given much smaller number of cases to process so that the person's time in detention is limited. Regardless of either one, the judges are being given specific number of cases. Basically, the agency decides how many cases you get. For the non-detained docket, as I've said, for these MPP or stay in Mexico cases, I'm hearing from my judges that they've been assigned upwards of 50, 60, sometimes 100, 120 cases for a session. So a case has to go through a number of hearings before it's ready for trial. At those initial sessions, certain basic fundamental principles have to be honored. So you need to explain to the person why they're there. You need to go through the charging document. You need to give the person the opportunity to seek counsel. If they are found to be in violation of immigration law, then the person has an opportunity to file their application, and they bear the burden to convince the court that under law they should be provided some protection. These things take time. Each time, depending on the particular facts of the case, the judge decides how much time the person should be given. Obviously, sometimes the government needs that for purposes of presenting evidence. This process before used to be much more within the control of the judge in terms of how many cases they believe they should be able to reschedule for their calendar. So if I felt that, okay, I can handle maybe 15, 20 for the next hearing, I'll do it. If I believe that this case is going to take a half day or trial or a full day of trial, I will schedule for that half day or full day. Our judges are now being told you have to schedule 3, sometimes 4 cases for trial. They're being told you have to put in 50, 60 cases for your initial cases, for your master resets, which are the time that people come back. Everything is being monitored very, very closely, micromanaged. And the judges are being told, these are not your cases. We can reassign these cases anytime we want. So if you don't show up, we're going to put somebody else. If you have one day that we look at your calendar and you have less cases than we think, then we're going to add more cases to that. If you schedule a case beyond a certain period of time, you're going to have to explain to us why you're scheduling it beyond a certain period of time. With the quotas and deadlines, they have imposed specific restrictions. So if there is a credible fear review or a reasonable fear review, which are very specialized types of hearing, you have to finish it on that first hearing, or now you risk your job. So there's always questions about why didn't you do it? Why isn't that happening? There are certain types of cases that they say you have to issue a decision that day. We are told oftentimes you can't even reschedule a case to issue a decision because you're supposed to issue an oral decision right then and there. Well, a lot of times I may be out of time. I may need additional time to think about it, but there's constant pressure. So the degree within which we are working under micromanaged, constantly shuffling, pressure, speed, it's frankly incomparable to what we had before. Yes, what we had before was also problematic, but we weren't subjected to quotas and deadlines. We weren't subjected to this level of micromanagement, and our decisions weren't being scrutinized the way that they're being scrutinized, not with the light of quality, with the light of quantity.
Hi, Louis Lebrecht from Bloomberg Law. A couple of quick questions. Someone mentioned a Fourth Circuit decision, and I was wondering if you could talk about what happened there, and are you trying to replicate that elsewhere? And then I also wanted to ask about you mentioned the General Counsel of the FLRA not being there. The Senate hasn't confirmed her yet, as you know.
Correct.
And so I was kind of wondering, I think that could take quite a long time with that. So I'm wondering whether you're looking at other avenues as well to address that issue.
Sure. I'll address your second question first, and the first one I may defer to the litigators. I can briefly talk about what the significance of the case is, but in terms of replicating in other circuits, it would have to be the litigators. It is significant for the general counsel position to have been left vacant by the administration for the FLRA. The general counsel position plays a critical role in allowing certain types of claims to work through the system and, frankly, to make it into the to the real courts outside of the Federal Labor Relations Authority. Recently, there was a lot of litigation relating to executive orders that were flat out hostile to unions, federal government unions, as well as federal government employees. The district court judge, in a very, very thorough analysis in a decision of about 100 pages, went through and explained how every one of those executive orders were in violation of law and intent of Congress. It went up to the D.C. Circuit, and the D.C. Circuit basically said, we're not going to get to the question, the substantive question. We're going to say everybody has to go through the Federal Labor Relations Authority, except you can't because there's no general counsel. At this point, as long as you are a federal government employee, you have to work through that system. So we are stuck, frankly, with this system of having to raise our issues through that system. We're doing our part, and we hope that it will eventually work. We are obviously fighting through the decertification, so we will make sure that the department is held to its burden, because they have to be the ones to show that somehow our position and our duties have changed in the last 20 years, which it has not. If anything, we have lost any authority that we had before. On the issue of the Fourth Circuit, the significance is pretty noteworthy, because it is a recognition of what we have been saying from day one, that to have a prosecutor being given the power to basically step in to court proceedings and unilaterally reverse a judge or rewrite the rules, that is not the kind of system we as Americans expect of our court system. But we have it right now with the immigration court, and the immigration judges have had to suffer with the loss of the authority to manage our docket through at least this one tool. And the Fourth Circuit, through a pretty reasoned decision, found that this is, that the Attorney General went beyond that.
How long ago was this?
It was about a month ago. It's Zuniga Romero versus Barr. Zuniga, Zuniga. The case number is 18-1850 out of the Fourth Circuit. Look, a lot of my cases can be resolved by other agencies. Okay? If I have a child that has been abused, neglected, or abandoned by a parent, that child may be eligible for something called special immigrant juvenile status. But Judge Tabaddor can't grant that status. That happens at USCIS. Mr. Zuniga, Mr. Zuniga Romero, wanted to pursue obtaining an immigrant visa outside of this country. He wants to go through the lawful system by being sponsored by his U.S. citizen relative, apply for a waiver that would allow him to come back, and then leave the United States to obtain his immigrant visa. But because of the Castro-Tum decision from Attorney General Sessions, he was stuck in immigration court litigating a case that no one wanted to litigate. No one needs to hear because the case can be resolved by another agency. And in Mr. Zuniga Romero's case, through him literally leaving the country and obtaining a visa to come back. So the decision is incredibly sound. It's remarkable because it was based, it's on the heels of the Supreme Court's Wilkie decision. And it's basically showing a new way of approaching deference to these agencies, which is if you're departing from the statutory language so much, we are not going to give you deference. We are going to stick with the plain language of the law. And we have a decades-old practice of administrative closure here that the Attorney General thought he could just remove like that. Fortunately, in the Fourth Circuit, that did not happen, and we're already seeing the results of it. The immigration judges, regardless of their particular bent on immigration law, are eager for independence. We heard the complaints during the Obama administration from some judges feeling like their independence was being infringed upon, and now we're hearing it now from all of the immigration judges. So we're looking forward to more decisions like Zuniga.
For what it's worth, I have probably 500 or 600 cases that would have been eligible for administrative closure, but I have to keep it on my docket and spend time on it. I'm not the only one who has had to suffer from essentially wasting resources and time for everyone to keep these cases, because I'm not going to push the case through closure because I took an oath of office. I'm not going to push this case and order someone deported when there is this other relief available if only the issues get resolved outside the court. So I'm going to hold a case. I'm going to probably be held accountable by, I have to answer for it, and I'm willing to stand up for it. But that was a key tool that was taken away from us. I don't have administrative closure authority yet. It's not, we're in the Ninth Circuit, we'll see. But just to give you some example of the effect of it on the docket, hundreds of cases that the judges will just have to continue bringing everybody back and spending time with.
So we are now out of time. I know there's some follow-up. So I'm certain that our panelists will be willing to talk more. So thank you, Judge Tabaddor, Judy Perry Martinez, and Jeremy McKinney for being here at the National Press Club.
Thank you for having us. Thank you. Thank you. Thank you very much. Thank you. My hands are cold.
Thank you, Allison.
I know.
In many ways for the reporters, and I just, we are behind you guys. No, seriously. I mean,
What is that?
we did that event last year in Freedom.
Oh, okay.
Yeah, and we really believe it. And it can't be only y'all talking.
I know. Well, we are
One of those values.
At least we have other megaphones that we can use.
You do.
A lot better than the people we're talking about today.
Yeah.
Do you mind sending me a copy of
Carol, oh, yeah, of course, Carol.
with
Of
you?
course,
I
I know that, it's mostly just because I'm working with
Yes,
people, and
absolutely.
I often find nuggets of this is something we
Oh,
can follow.
good.
Right, no, happy to.
That would be great.
They'll help me do
Would
it.
you
Thank you
And
so much.
do people tell you you look like Jeremy Renner?
He does, he does, he does.
You
Well,
were speaking and I
We can
wasn't
be of
listening.
help, if there's any sort of
Often
that
joke
you
that
think would
Jeremy
be helpful to
Renner had an
explain to
addiction
them
to
how the
McDonald's.
process works. Walk them through some of the court
Thank you.
procedures manual.
How are you?
Sort of just acclimate them to the system.
Yes,
We're happy to accommodate.
But I saw you from 3 gyms from Judge Scouts this morning. One win? No, I know.
Please say hello. Thank you. Pleasure. Sorry,
Oh,
I'm
no,
so
enjoyed seeing you.
Thanks, Dave.
close. I mean, she was a great litigation.
Oh my God, of course. Oh yeah, you can tell. You can absolutely tell. It's just moving, and you're not reading the way I'm reading. So. Hi.
Louis Lebrecht.
Yes, yes. Likewise. Likewise. Thank you.
Yeah, so I wanted to. He did reach out and legislation. Actually, it wasn't directly.
Which legislation, the Article 1? Yes, the Federal Bar Association.
So my feeling is, I don't want to use the perspective.
It's a really good question. We have a lot of people actually on the Hill who have expressed a lot of commitment to it, both as a matter of principle and practice. One of the issues has been what model, right? What's the best model to come up with in terms of,
It's actually,
is it
Charlotte
an
is,
FBA model? Is it a bankruptcy